Make sure I can see it. Okay. Do I have all of my stuff? Okay, I think I do. Hello, hello. Oh, no, we can't see him. Can't see you. Let's bump this up a little bit. There we go. I was trying to be. It's gonna take me a little bit to get back into the groove, everybody, but welcome. Hello, hello, hello. Thursday night, right? Last I checked. Thursday all day. Hello, hello. Welcome, welcome in, everybody. I did a live a little earlier today to kind of do a little soft reopening, but kind of wanting to jump in here tonight. But you'll have to forgive me. My voice isn't 100% back. I still have, still not quite 100% yet, but we'll be soon. We'll be very soon. I have an optimistic look at it. That's what I'm going to say to myself. I'm going to say, you know what? We're going to be all right. We're going to be all right. Oh, thank you so much. Thank you. Welcome, welcome. Hello. Hi, Amanda. Welcome in. Good to see you. I hadn't really planned to go live tonight, but you know, there's been a lot of talk about this Hatch Act situation, and I thought, let's do that. Hello, Deb. Kaya, good to see you. Oh, no, excuse me. No problemo. Earlier, I did go through the DC Chief Judge has set out an extension for timelines for things that are due in court, and he's given the parameters of how he would prefer to have that done. So just because the government shut down, so he's like, you all can have a little bit more time, except for on very important stuff. So like, oh, absolutely, Violet. Oh, I'm happy to. You know, it's been a while, actually. This one I had to kind of dust off. I have a full live going over this, over on my, sorry, that was my pen, over on my Tube of You. Now, you'll have to go into my long videos because I made the video like 2 years ago. So you have to scroll back a little bit. But that is another resource for you. And I thought, well, you know, this was very informative. So good for me. But let's do it again. Let's get something more up to date. Oh, thank you so much. Oh, I appreciate that. Hi, Army. Oh, my gosh, Army. I came earlier to your live. And I was kind of floating around and I was getting ready to come on up and hang out. And then my mother called me and I was like, oh, shoot. So had to step back, but hopefully next time. Tracy Bean, yes, I am back. I'm back. Yes, we're just starting. We're just getting started here. I'm giving everybody a little chance here to get their notifications. This was not scheduled, so nobody missed, you know, a scheduled situation, but I wanted to hop on tonight. There have just been so many questions about the Hatch Act, and I recalled that I had done previous work explaining how the Hatch Act works, how it functions, using this report that had been put together by the Office of the Special Counsel. So, you know, there's a lot of stuff in the world that's available to us from the people who no longer work there. And so I think it's important to utilize your resources, of course. So this was a report that had been put together going through specifically Mr. Orange's administration and where the violations were. There were a lot. But I think especially right now, it's helpful to have the overall summary and the Hatch Act itself explained. So I thought that might be helpful. We'll just hit those two highlights there and talk about it a little bit. And any other, yeah. I mean, it's, I think they could do better, but you know, they don't. They don't do better. And then we're all like, all right, what's happening this week? What's going to explode? So let me go ahead and get my sticky note out here, everybody. Again, I'm not quite 100% yet, so my voice is a little bit scratchy and I still have a bit of a cough, so I apologize, but hopefully everyone can kind of look past that. I would appreciate it. All right, so this is going to be the Hatch Act here. Hatch Act. Explanation is what we're doing. Is there an I in there for explanation? Somebody help me out, chat. Is there an I in there? Hello. Hello, good evening. Welcome. Big Grandma, oh, it's good to see you. Yeah, it's been a while since I've been on. Hi, hello. Yes, I'm back. mostly back. Doing my best. Oh, thank you so much, Allison. Okay, thank you, Diana. Oh my gosh, thank you, Boxer Mom. Okay. What would I do? I just don't even know. I know I'm just terrible at spelling explanation. But if you want me to break apart the 21st Amendment, I can do that for you. but proper spelling, no, that's it's not my wheelhouse. Hello, Elise. Good to see you. Oh my gosh. Hello, Blue Horizon. Hello. Yeah, oh, is Brian on? Oh my gosh, he's so fabulous. We love him here. All right, so we're going to talk about the Hatch Act, and we're going to go through this report that was issued back in 2021. All right, so report here. So again, this is public information available to anybody that would like to pull it up online and print it out like I have here. This is a public document. There's nothing secret about it. We try to make sure most of our stuff is pretty transparent in the legal world. So this is one of those. Hello. So I do have the full reading of this also available on the tube from a couple years ago when it first dropped. But tonight I thought, let's go through this again. Let's take a look at it. Let's see what's going on over here with the Hatch Act, because that can kind of get tangled up a little bit. All right, so let's get started here, everyone. Again, forgive me, my voice is a bit rumbly still, and we'll see how far we can go, but such is the way of life these days. All right, so let me just show you real quick what we're talking about when we're talking about the Hatch Act here. So the Hatch Act comes out of Title V of the U.S. Code. So, and they are saying, well, this is commonly referred to as the Hatch Act. So we have our title in here. Section 1 is the short title. The act can be cited as the Hatch Act Modernization Act of 2012. There's multiple pieces in here, and I'm not going to actually read through the Hatch Act because there's a great explanation coming up here in this other document I want to read. But for people who are wondering, like, where can I find the act itself? Where can I get that language itself? This is where it's at. So it's Public Law 112-230. And you can pull it up, take a look yourself, and read that. But we've got only 2 pages here, so not terribly long. So it's good for us to just dive right in to this report here so we can kind of get her done. Okay. Yeah, and I do have a cough drop, everybody. Hopefully that won't be too frustrating. So here we go. Investigation of political activities by senior Orange administration officials during the 2020. I'm going to just call this an Ellie, okay? Our words right now are so incredibly, have to be very, very careful here. So we're going to say Pres Ellie, all right? So, follow the bouncing ball. This report was put together by the U.S. Office of Special Counsel on November 9th of 2021 after a full investigation. And they do go through and explain to us what the Hatch Act is. So this will be the first one coming up. Yes, the Orange administration. Again, I'm not saying that to be intentionally derogatory. I'm saying that because a lot of words right now are getting people into trouble. So here's a table of contents for this report. Part 1 is the executive summary, and I will go through that because it gives us an overview of what this report's about and also how the Hatch Act is used. Next, we have the Hatch Act itself, and they'll go through an explanation of that. And then Part 3, of course, goes through and sets out all of the Hatch Act violations from Mr. Orange's administration. And this was in his first administration. Okay, so lest we forget, this was his first administration. So the big pieces here they are going into is the 2020 I don't know, I don't know if I can say that word or not. National Convention generated substantial public discussion of the Hatch Act and an unprecedented number of Hatch Act complaints. Number 2, OSC received, so this is the Office of Special Counsel who's putting this report together, received numerous complaints alleging that senior Orange administration officials violated the Hatch Act in the months prior to the 2020 LE here. And then the legal standard required to establish a Hatch Act violation, we'll take a look at that. Employees described in this part were all covered by the Hatch Act. So you have to see who was actually covered. And it is a prohibited use of official authority for an employee to support or oppose a candidate for a partisan political office while acting in an official capacity. All right, so that's number 3. And what we're doing then is we're going to, of course, everyone's probably heard that we've got some partisan language that is directly on certain government websites where it should just not be. It's totally inappropriate. And that the places where they're at, we're supposed to not be political at all. And that language has gotten in there through emails, through the websites themselves. So we'll take a look at that. Number 4, the subject officials violated the Hatch Act by campaigning on behalf of Mr. Orange's re-LEs while acting within the scope of their official duties. So again, it's not that you can't have any, campaigning going on. It's that you can't do it while you're in your official place. You did, okay. That's what I'm saying. Now, just as a friendly reminder, because this report is on the first administration, I do want to just set out here the rest of the table of contents to give you some idea of what it's about in case you'd like to pull it yourself. This is the set of 11 senior Orange administrative officials that violated the act during official interviews or media appearances. And this is what's taking you down, people. If you knew exactly what it was that was hurting your dream goals, it's like, well, why don't you stop? But they don't. They go and they do interviews, they do media appearances, and the entitlement is so thick that they don't realize the confessions. I mean, that's basically what it is. If you were investigating a crime and the perpetrator would go on to the news and start talking about, well, yes, of course I did it, and here are the steps I did. That's a confession, and you'd be like, woohoo, yay, we're gonna win the case. That's what's happening here. So, there's not a lot of wiggle room here when it's all put out into the public. And I understand their motivation and their rationale. The rationale is that we are above all of the plebes, and so we can do what we want. But in the end, we will see. Right. All right, so let's just remember, let's just go down the memory lane here. We have Secretary of Energy Dan Brolette, Senior Counsel to the Prez, Kellyanne Conway, White House Director in Strategic Communications, Alyssa Farah, U.S. Ambassador to this place, which I'm going to call the I place, David Friedman, Senior Advisor to the Prez, Jared Kushner, White House Press Secretary, Kelly McEnany, I'm sorry, I don't know how to say her last name. White House Chief of Staff, Mark Meadows, Senior Advisor to the Prezi for Policy, Stephen Miller, White House Deputy Press Secretary, Brian Morgenstern, National Security Advisor, Robert O'Brien, Chief of Staff to the VP, Mark Short. Again, this is the list of all the people that violated it. So there you go. We have here, thanks, Big Grandma. So next we have up, again, the details of the report. So we've got senior administration officials that have violated the act during the National Convention. They were going through that. Specifically, the findings of Secretary of State Michael Pompeo and the Jerusalem speech. Oh, I hope that word's not a trigger. An analysis of Secretary of State Michael Pompeo and the Jerusalem speech. Number 3, factual findings, Acting Secretary of Homeland Security Chad Wolf and the naturalization ceremony. Number 4, the analysis, Acting Secretary of Homeland Security Chad Wolf and the naturalization ceremony. Again, I'm just walking through a table of contents here. Number 5, the Orange administration ignored the Hatch Act and approved of senior officials illegally campaigning on behalf of Mr. Orange. So the Orange administration refused to hold senior officials accountable. This is probably the biggest piece of this report. Is they, again, I'm not going to read the whole report. We're just going to kind of talk about the Hatch Act here. But when they were doing all of this investigation, they had all of this evidence, and it was so clear there were violations. But the biggest issue is that the administration refused to hold them accountable, right? So we have a law, it's being broken, and they're withholding prosecution, right? So, which, that's kind of the thing that they can do that is kind of troublesome here. So, Orange administration refused to hold senior officials accountable for violating the Hatch Act, and in at least one case publicly defended a senior official who Office of Special Counsel found had violated the act. I don't think, again, there's anyone left in this office anymore, but the Orange administration took no apparent action to control or prevent senior administration officials from committing frequent and similar violations of the Hatch Act. And then we have enforcement challenges down here. And this is something that I think is really important. I'm going to just summarize. There's a problem with our Hatch Act because we have some enforcement challenges with it. So the enforcement tools are limited with respect to any Senate-confirmed presidential appointees and White House commissioned officers. So one thing that I would talk about or think about here when we're talking about those websites, everybody, is who put that there, right? Who's in charge of that? Who put that there? Yes. No, I'm sorry, Brandon. No, this is the his first administration. All right. I think that was 2017. Yeah, we'll just say that. Right. Oh, absolutely. Full credit. Oh, sure. Of course. So, first administration. And they're listing all the people like in his cabinet that should know better. But what we're going to be talking about are who put it up on the internet, right? Who put it into the websites. So the enforcement of these other pieces then are not going to be similar to what our practical application is. So we'll kind of move forward there. I've got to be very careful about what I use my voice on. All right, so 25th Amendment, how it's applied. Oh, Philly, I just posted on that. I just posted on it. Oh, where's my other Constitution? Yeah, so let's actually break for a minute, Philly. Let me explain it to you real quick here because I think it's so important. Whatever, I don't know where I put it. Oh, let me see. Oh, okay, hold on. There we go. Oops. Care Bears. Real quick, everyone. Let's just look at the 25th Amendment. It's incredibly quick to get through this. So let me explain this real quick, all right? So the 25th Amendment, 1967. In case of the removal of the president from office or if his unalive or resignation, the VP shall become president. Section 1. Got it? All right. So anything happen? We've had 8 presidents that have not made it through the presidency. All right, boom, VP takes over. 2, whenever there's a vacancy in the office of VP, the president shall nominate a VP who will take the office upon confirmation of the majority of Congress. All right, got it. Number 2, VP. Number 3, whenever the president transmits to the president pro tempore of the Senate and the Speaker of the House his written declaration that he's unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the vice president as acting president. So he can write and say, hey, I like to give the Ronald Reagan example for Section 3, where Ronald Reagan's like, I got to go in for surgery. So I'm not going to be available to do my duties for the next 6 hours. So the VP takes over during that period of time. All right. So Section 3 is like, I've got a doctor's appointment. I'm going under. Here is the next one. And the biggest piece most people are talking about here is Section 4. All right. So super quick. Whenever the vice president and a majority of either the principal officers of the executive departments, so that's the cabinet, all right, so the majority of the cabinet, We have 13 people, so that would be 7, right? That's right, isn't it? 13 people on the cabinet? 15. Okay. It's math. I'm not good with that. So, or of such other body as Congress may by law provide. So Congress can also say, well, we don't want the cabinet, we want something else, and they don't have anything else at the moment. Transmit to the president pro tempore of the Senate and the Speaker of the House of Representatives a written declaration the president's unable to discharge the powers and duties of his office. So we'll pause here at this comma. So it doesn't say why. It doesn't say why they can't. The vice president and the majority of the cabinet can just say he can't do it. Write it down, send it to Congress, and they are in compliance with Section 4 here. All right. The vice president shall immediately assume the powers and duties of the office as acting president. So he can just take over. If he and the cabinet agree, they send it to Congress, he takes over. Next, thereafter, when the president transmits to the president pro tempore of the Senate and the Speaker of the House here of Representations, his written declaration that no inability exists, he shall resume the powers and duties of his office. Pause again. So he can write a letter and say, I'm actually perfectly fit. I'm great. And so, boom, now he's back in power. He shall resume the powers and duties of his office unless the vice president and a majority of either the principal officers of the executive department or of such other body as Congress may by law provide, which they have not, transmit within 4 days to the president pro tempore of the Senate and the Speaker of the House of Representatives a written declaration the president's unable to discharge the powers and duties of his office, period. So let's pause here for a second. All right. So the vice president and the majority of the cabinet write a letter and they're like, dude, he can't do it. And so then he writes a letter and he's like, yes, I can do it. And then they immediately write another letter saying, no, he cannot do that. Thereupon, Congress shall decide the issue, assembling within 48 hours for that purpose if not in session. If the Congress within 21 days after receipt of the latter written declaration written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determines by two-thirds vote of the House and of both houses, the Senate and the House of Representatives, so that's a supermajority, that the president's unable to discharge the powers and duties of his office, the vice president shall continue to discharge the same as acting president. Otherwise, the president shall resume the powers and duties of his office. So ultimately, then Congress has to decide. All right, so it's a 3-part piece here. So this is our lightning round explanation. All right, so the 25th Amendment sets out, this is our lightning round. Number 1, we're going to say an unalive situation, okay, for whatever reason, maybe get sick, whatever. Number 2 is the VP. What happens to the VP? So that's decided there for number 2. Number 3 is what, I've been calling the Ronald Reagan provision, or kind of a letter saying I can't do it by president and then revoked, right? So, I'm going into surgery. All right, so we'll do surgery here. And then number 4, this is the one everyone's talking about, okay? We have the VP. We have the majority of the cabinet. For any reason, it doesn't specify what reason, but for some reason, saying that that the president can't fulfill it, that letter goes to Congress and boom, it's done. And then the president can come in and send another letter saying, I'm fine. And then the VP and the majority of the cabinet can say, no, you're not. All right. And then after that, Congress picks. Congress decides. All right. So this is like Schoolhouse Rock without the music. All right. Does that make sense, everybody? Okay. 8 majority. Thank you, VC. I appreciate that. I was wondering about that. I get my numbers mixed up sometimes. All right. Everybody follow me. Super, super simple. Super simple here. And again, the 25th Amendment's been discussed quite a bit. And the reason is because of this number 4, where the vice president can basically step in and say, dude, you can't do this as long as the vice president gets the majority of the cabinet to help him. Now, technically, Congress can come in and write a law saying you don't have to have half the cabinet. You have to have like the, DNR or whatever, technically, but we don't have that on the books yet. So, yeah, Congress decides, well, it's not quite like impeachment because the houses work together in all of this. So in impeachment, the House decides impeachment articles, and then the trial's in the Senate. And here, it's like the Congress just has to agree. Did I discuss this a year ago? Absolutely, I did. I've been discussing the 25th Amendment for all 3 years here. Heck yeah, that's one of the most important things. Can the president fire the VP? Interesting question, but I believe the VP can only be removed the same way as the president, which would be impeachment. Oh, yeah, of course. So, and again, everyone, with impeachment, you need to have high crimes, misdemeanors. Then you are charged with those basically in the House, and then the Senate holds a trial, which is presided over by Chief Justice John Roberts. All right, so that's how that goes. But the Vice President has a special role here. Oh yeah, we go over all amendments. I don't think any amendment can be left on the floor. I think they're all important. And in order to really get a proper perspective of your rights, I think it's very important to go through all of them. Well, we're not sure. And NYC, I think the way it's been done, certainly it did not work. You're absolutely right. So I don't know if it was the people or the procedure. And that's something that we'll see later on down the road. Right. All right, well, let's dive in then. Again, forgive me. I am coming off of a very bad cold situation. I am back, but I'm not quite 100%. Oh, Spiru. Oh, I know. Oh, my gosh. Oh, man, the story that he has to tell. He's probably like, that's not right. What's happening right now? Yes, and as a quick disclaimer, when I come on and do my lives, I have a lot of new followers, everyone. And I'm so glad you're here. My lives are just educational purposes only. I'm just taking you through different documents and explaining what it means. There's no legal advice that I give out here. I do have over 20 years experience as an attorney and have taught as well, which I really love to do. So that's why I'm here over on the talk, is just to kind of explain things. I'm not really here. I don't debate. If you want to hear me debating, you can catch me on a panel, although you might not want to. But when it's my life, I pop it up, I put up the paperwork, and I explain it. That's all there is to it. So we kind of keep this a bit free of politics as best as we can. And just look to the letter of the law here. I have no affiliation one way or the other here. My only allegiance, of course, is to the Constitution. All right. My panel spicy. Yes. Oh my goodness. All right. Here we go, everybody. We're going to go through the executive summary. It's only a couple of pages, kind of setting out what this report is about. Again, this was for the first, very informative. Oh, thanks. I'm so glad. This is the first administration. So here we go, everyone. Part 1, executive summary. This report presents the United States Office of Special Counsel, so OSC, and of course they've all been fired in this administration now, investigative findings and conclusions regarding complaints OSC received largely in response to the 2020 Republican National Convention, alleging that senior Orange administration officials used their official authority or influence to interfere with or affect the 2020 Pres Eli in violation of the Hatch Act. As described herein, OSC investigated those complaints and determined that hosting the RNC at the White House did not itself violate the Hatch Act, but that at least 13 senior Orange administration officers, officials, did violate the Hatch Act prior to the Eli. Each of these high-profile violations was committed by an official OSC believes, based on current law, could only have been disciplined by then President Orange. Thus, the cases described herein demonstrate both a willingness by some of the Orange administration to leverage the power of the executive branch to promote President Orange's re-ele and the limits of OSC's enforcement power under the existing statutory scheme to prevent them from doing so. So they're pointing out we've got a bit of a problem here in the Hatch Act. We've got an enforcement issue. And if the Prezi doesn't go along with the OSC, with their reports, if they're like, okay, yeah, they violated it and I don't care, there's not a lot they can do. And the law was written that way, of course, because before that, we didn't ever have a president that didn't want to comply with the law. So just keeping that in mind. OSC is issuing this report to educate employees about the Hatch Act, prohibited activities, highlight the enforcement challenges that OSC confronted during its investigations, and deter similar violations in the future. Yeah, I don't want to get my I don't want to get my live busted here, so I do have to be careful with my language, right? There are many other names. For me, I don't mind calling out fruit baskets here. All right, so number one here, and again, that enforcement piece is pretty senior Sunny. Yeah, the good old days. Oh, that's a good question, Dominus. That's a very good question. Or the question was, will this open the door for more corruption prezis in the future? To that I say, each time they get some kind of a victory, they try it again and try to get more, right? So they're in the courts. So every little win that they get, they come back and they're like, we want more, 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 more. So this will be a moment in time where we figure out if the American people understand what's happened and keep it from happening again. That question is up for debate. During a press conference on August 5th of 2020, President Orange was asked about the Hatch Act implications of using the White House as the venue for the RNC. He responded, quote, "There is no Hatch Act because it doesn't pertain to the president," end quote. Although true that the president is exempt from the Hatch Act, the law most certainly does apply to senior members of the president's administration. Nonetheless, with respect to an administration's senior-most official, whom only the president can discipline for violating the Hatch Act, the Hatch Act is only as effective in ensuring a depoliticized federal workforce as the president decides it will be. Where, as happened in the Orange administration, the White House chooses to ignore the Hatch Act requirements, there is currently no mechanism for holding senior administration officials accountable for violating the law. This is just so important, everybody, all right? It's so important today, especially today. We have to remember that. We have rules, but if the rules are not written clearly by Congress without appropriate enforcement and accountability, then the rules don't work, all right? So that's kind of what they're saying here. Now, let's bump down here to footnote number 1 here. Hopefully everybody is able to see here. It looks like the paper's covering all of my comments, so I'm just curious if you could give me a heads up. Can you guys see the comments? Guys and gals and pals? Exactly, Karma, exactly. But on these subject matters, precedent will already be adjudicated. I'm not sure what you mean by that. I'm not sure what you mean by that exactly. Okay, thanks, Thomas. Yeah. So what I'm specifically talking about is how the Hatch Act is written. The only person to enforce it is the president, and that's, I mean, is that what you mean by precedent? Like, that's how the rule was made. Yeah, sorry. Let me think about it. Let me chew on it and then toss it back to me later. We can talk about it a little bit more. All right, here we go. Part 2 of this report briefly describes the history of restrictions on federal employees' political activity and the developments that led Congress to pass the Hatch Act in 1939. Hiya, Bathuru, good to see you. It focuses in particular on why Congress chose to prohibit federal employees from using their official authority or influence for the purpose of interfering with or affecting LEs. Again, I'm going to be careful with my language. I'm going to pause here because I want to take a moment again to kind of put out this immunity fire that people are so worried about, and rightfully so. But I want to just draw your attention to this, okay? So when we're talking here about the Hatch Act, using their official authority or influence for the purpose of interfering with affecting LEs, right? This is the same standard as what is in the immunity decision, all right? That's the same standard. So official authority here is the only thing that's covered here. So remember that when you start to panic in the middle of the night and you're like, oh, he's gonna get off anyway. No, it's official, all right? I like to point that out just as a friendly reminder. This is a standard we use in all kinds of stuff. So it's not that bonkers that the Supreme Court would say that. The rest of it that the Supreme Court said, yes, bonkers. But this standard here isn't new. Part 3 contains OSC's determination that some officials in the Orange administration intentionally ignored the law's requirements and tactically or expressly approved of senior administration officials violating the law. Many of the complaints that prompted this investigation were filed during or after the RNC, which, because of the C-19, featured events held on White House grounds. As far as the OSC is aware, it was the first political party convention since passage of the Hatch Act to do so. Again, that was 2012. The complaints raised 3 issues. So we'll set those out. Yeah, tacitly, all right. Boy, I've been pronouncing a lot of things incorrectly recently. All right, here we go. The first issue, again, this is to give you an idea of how the law works. How does the Hatch Act function? The first issue is whether President Orange or then Vice President Pence violated the Hatch Act. The Hatch Act neither did, because both the president and the vice president are expressly exempt from the coverage under provisions of the Hatch Act that the OSC enforces. So they're not included. So the president cannot violate the Hatch Act, and neither can the vice president. All right, so they're off of the table here. Oh, should I build my vocabulary, Joseph, in Texas? Maybe I should. All right, number 2, down here. The Hatch Act also contains criminal provisions, but those are outside of OSC's jurisdiction. As used in the report, the term Hatch Act relates only to those matters within OSC's jurisdiction. All right, so down up here. How does this apply to checks and balances? Well, they do discuss that, so we can dive into that issue here in just a little bit. I do want to try to make it through these few pages here, even though I'm narrating. Here we go. The second issue is whether the Hatch Act prohibits a political party from holding a convention at the White House. That's a good question. It does not. And I think that's good to know the answer. We've got a solid answer here. The Republican National Convention could be held at the White House, and that is okay. That is not a violation. The Hatch Act only applies to federal executive branch employees, assuming that the president or the vice president, neither of whom is subject to the Hatch Act, authorizes use of the White House for a political convention, and the convention itself is produced by non-federal employees. That circumstance alone would not violate the Hatch Act. As an OSC said publicly during the RNC, ambiguities in existing law means that there are certain areas of the White House and its grounds in which even federal employees are permitted to engage in political activity. So this is something that we may see with the issue we're dealing with today, of the kind of negative politicking being put onto government websites, right? So one of the things that they pulled out that's an issue is to say, because president and the VP aren't included in it, if they're the ones that ordered it, then the action may still not be a Hatch Act issue. It might, but it's unlikely. All right. Right. Next here, the final issue is whether a number of senior Orange administration officials violated the Hatch Act in connection with the RNC or otherwise prior to the 2020 LE. OSC concludes that at least 13 senior Orange administration officials did so, and furthermore, that they did so with the administration's approval. Under current law, OSC may seek disciplinary actions up to and including removal from federal service against most federal employees who violate the Hatch Act by prosecuting alleged violations before the Merit Systems Protection Board. So, again, pause, because this board is almost completely been demolished. So this board that you're supposed to go to here, the downsizing of it and the way that they've handled all of our executive boards, there's like nothing left of it. Oh, thanks, Big Grandma. That's right. A little tea here. I only have a few pages I'm going to read tonight to protect my voice, so no worries. So, right, and as we look back at a lot of these things, everyone, I'm just going to highlight if it's been dismantled or not, all right? Because that's something. Oh, Mr. Mayo, welcome. But in the case of violations by Senate-confirmed presidential appointees, and in OSC's view, also by commissioned officers, within the executive office of the president, OSC may only submit a report to the president. This is both legally required, as OSC believes there are significant constitutional concerns with the MSPB disciplining commissioned officers. All right, so they're already going after him, which is, normal. And as a case during the entirety of Orange administration, it is then up to the president to discipline those employees. President Orange not only failed to do so, but he publicly defended an employee OSC found to have repeatedly violated the Hatch Act. This failure to impose discipline created the conditions for what appeared to be a taxpayer-funded campaign apparatus within the upper echelons of the executive branch. And it allowed for, as one federal court said of a senior administration official, members of the administration to violate the Hatch Act with seeming impunity. So you just kind of let it go. How could it not be because the president and the vice president did not actually do it? So if they ordered it done, is what the special counsel is saying. If they ordered it done, it's enough of a connection that would eliminate the Hatch Act from being used. Can the DNC sue the Gov for defamation because they've clearly made? That's a good question. Then that would be, I'm not sure. Because that's kind of, we're in a political speech world. First of all, political speech, which has just been made up. We've only used that term in the last few years. But I think there are some protections in place for language when you are campaigning. So it would be very, very unlikely. What's so bad? What's so bad about what? And what's the charge? There's no charge. No, this is a report. All right, now, let me just fast forward. Oh yes, the echelons. Okay, all right, we finished here. Moving on to the next one. It's crazy it doesn't apply to the P and the V. Well, I agree, but again, I'm trying to use the presidential immunity case as much as possible to just kind of continue to explain what the H that was, because that was some crazy business. But there are certain things in the Constitution that are executive powers, are executive things. And so Here, like pardons, we'll just use that as an example. The president has pardon power. So that's basically genie power over pardons. And so if somehow the pardon had something to do with the Hatch Act, they're trying to say here the president can't be held under the Hatch Act for it because it's one of those presidential powers exclusively. All right, so they're just trying to make sure that there's no extra door to have that open. No problem. No problem. Okay. All right, VC, I see you got it. So here we go. OSC received complaints alleging that the 13 senior Orange administration officials listed in Part 3 violated the Hatch Act in one of two ways: by making statements supporting or opposing a candidate for partisan political office while speaking in an official capacity, or by using their official authority in connection with and in furtherance of the RNC Section 7223A1 of Title V of the U.S. Code, which prohibits federal executive branch employees from using their official authority or influence to interfere with or affect the results of any LE. Under that prohibition, it's illegal for an employee to support or oppose a candidate for partisan political office while acting in an official capacity. And I can't help but think that that's actually happening quite a bit. And let me pause here for a minute. And one of, I think, the most important questions to figure out when we're talking about the Hatch Act is why? Why would we do that? Why would we have a law that says federal employees can't go forward on partisan politics as a federal employee in their capacity as an employee? Why can't they do that? Why is that speech being limited? So that's my question to the chat. Why are we limiting the speech here? What's going on that makes it okay for us to have a law that says you can't talk about this stuff? I'm just curious. It could interfere with the right. Nonpartisan, right. They aren't elected. Okay, yeah, that can make sense. Sure. Any other reasons why they would even have the Hatch Act here? Like, what's the big stinking deal is the question, right? Influence. That's exactly right, Karma. Okay, so back in the old days, everyone, people used to feel like the government could be trusted and relied upon. And so if the government came out and said something, they had more weight to their to what they were saying than anyone else did, because you believed them, you trusted them. So by having someone in an official government position talking about politics puts extra weight. You might say, oh, well, that person's been, the federal employee really likes this person, so they must be right because I'm going to give the benefit of the doubt to the government. All right. And that was back in the old days. What an interesting moment we are having in history now. Because, and one of my favorite quotes is from, I don't know who that fella is, some of that weird little old fella who was like, defamation doesn't work for Mr. Orange because Mr. Orange's reputation's shot. Like, it can't be any worse. And that's the same here for the government. Like, the Hatch Act may not even be needed because the reputation of the government is so bad that no one's going to trust the government anyway. Right? Am I right? Appeal to authority? Absolutely. Yep, absolutely. Right. All right, so we'll keep that in mind. We may not even need the Hatch Act for a while. Yes, 2 times in one day. Extra hydration. All right, so yet Orange administration officials did precisely that. And while the specific facts of each case are different, they share this fundamental commonality. Senior Orange administration officials chose to use their official authority not for the legitimate functions of government, but to promote the re-ele of President Orange in violation of the law. The administration's willful disregard for the law was especially pernicious, considering the timing of when many of these violations took place. OSC cannot, in most cases, stop violations from happening in real time. Even apparently straightforward violations of the Hatch Act may not turn out to be actually be violations upon further investigation. Therefore, investigating alleged violations is the only way to ensure a fair result. Accordingly, OSC affords appropriate due process. Sorry, everybody. Hold on a second. I want to make sure, whenever I get into a due process piece, I want to make sure I have that highlighted. Okay, affords appropriate due process to the subject of the complaint and gathers the relevant facts before reaching a conclusion. As a result, OSC's investigations can often stretch out for weeks or even months. This reality creates a window for an administration that is so inclined to ignore the Hatch Act within the final months of an LE cycle, knowing full well that any public report or disciplinary action would not likely occur until well after the LE. However, the benefit to the administration and results harm the use of official authority or influence to interfere with or affect an LE. And this would accrue on or before the LE day. As described in Part 3, OSC has concluded that the Orange administration, VC, it's here again, that word I couldn't say. All right, or expressly approved myriad Hatch Act violations committed within that critical period immediately prior to the 2020 LE, during which OSC was unable to both investigate and resolve the violations before LE day here. All right. Okay, so I'm gonna kind of fast forward here again a little bit, just to make sure I can kind of get the highlights picked out before my voice goes. Now, the next piece of this I think is very helpful. Again, this is a public record. You can pull this up yourself. On page 4 in part 4, they start going through the challenges faced by trying to get this enforced. All right, so they have bullet points for each one of those. And whomever wrote this, and I'm not sure exactly who the person was that wrote this, not happy about it. Not happy about the enforcement piece. Very frustrated with that. All right, so that's part 1. Let's dive into part 2 so we have, again, a better idea of what the Hatch Act is. You're going to be hearing, here's the thing, everybody. You're going to be hearing about the Hatch Act like 24/7 for the next week because of what they have done by putting partisan political comments into emails for veterans or HUD housing or various other things. So you're going to be seeing this a lot. So what's important here is that you know what the Hatch Act is, you know what it does, you know what it's for, and then you'll have a better understanding of what they're saying. Oh, Thomas, you're so sweet. Is it bunker time? No, but I am stockpiling. No. No. I've already set out a couple of things. I've set out a timeline, and there are a couple more bumps on the timeline we need before it's bunker time. But if that happens, yeah, I'm going to the bunker. Oh my gosh. All right, here we go. Let's talk again about what the Hatch Act is. This part describes the developments that led Congress to pass the Hatch Act and why Congress chose in particular to prohibit federal employees from using their official authority or influence for the purpose of interfering with or affecting LEs. All the violations described in Part 3 implicate that prohibition. Both the Orange White House and some senior Orange administration officials argued that the conduct at issue, in essence, campaigning while acting in an official capacity, was not the sort of conduct that the Hatch Act was meant to prohibit. But the historical record shows that one of Congress's motivations in passing the Hatch Act was to prevent the creation of a powerful, invincible, and perhaps corrupt political machine using thousands or hundreds of thousands of federal employees paid for a public expense to a political party's political structure and political campaigns. Amen. This is one that should be shouted from the rooftops. All right. So what was it exactly that they had the Hatch Act for? Well, let's go back here. Okay, what's the reason for it? In passing the Hatch Act was to prevent the creation of a powerful, invincible, and perhaps corrupt political machine. That's what it was for. OSC therefore recounts that historical record before analyzing the individual violations in Part 3. Oh, I know, right? I know, right? All right, so we'll just do a couple paragraphs here. You know how I feel about the history. I'm all about it. That gives us a way to understand why we're doing what we're doing. I think one of the things that can be very difficult is if you have no idea why you're doing something, why are you doing it then? All right, here we go. The Hatch Act. All right, the Hatch Act is the culmination of efforts dating back nearly to the country's founding to limit the partisan political activity of federal employees. The underlying rationale for those efforts is that efficiency in government service requires a lack of partisanship in administration. Oh no, everybody, I got a puzzle piece. And I tell you what, isn't that the truth? Isn't that just the truth, though? Oh, I got it on first try. Good for me. I'm so proud of myself. All right. So you're like, well, why can't the president just do whatever he wants? Well, it's right here. Somebody print this out and give this to the SCOTUS. Because you can't. You're not supposed to. All right. Yet historically, the executive branch was staffed largely through political patronage, i.e., employees owed their employment to the political party in power. So conflict of interest arose when those employees had to decide between using their power and authority for the general public welfare or for the benefit of their patron party. This is so important because that's exactly what the issue is, right? Are we here to help the entire country, or are we here just to help whomever's in the White House, right? I mean, that's the key question. The nation's experience with the patronage system led Congress to mandate primarily through the enactment of laws such as the Pendleton Act of 1883 and the Hatch Act of 1939 that such conflicts be resolved in favor of the general public welfare, and that the power, prestige, and influence that executive branch employees wield must not be used for partisan advantage. Right? This is precedent in case SCOTUS doesn't understand. All right. So we're not just making it up. We're not just like, well, you're supposed to be, nonpartisan. Well, that's, what they all say. No, it's like, this is how it's always been, man. This is what it was supposed to be. Like, this is what George Washington told us to do, Why are they going against Washington? Sorry. I got my soapbox. All right, here we go. As early as 1801, Thomas Jefferson recognized that the party in power could use the federal government to influence or control LEs, thereby becoming impervious to the electoral will of the people. Man, Jefferson, I tell you, back again. He wrote that interferences with LEs by officers of the federal government will be deemed cause of removal because the constitutional remedy by the elective principle, because nothing, if it may be smothered by the enormous patronage of the federal government. In his view, executive branch interference in LEs would end the American experiment in self-government, replacing it with a system of perpetual one-party rule. And again, that's something that I think a lot of people have forgotten about. Like, is that what you want? You just want one party? Like, we're calling another party really bad names. So let me pause for a moment and just kind of set this out for everybody, for all people, okay? And I bring this up not to be political, but I bring this up because I'm hearing it so much on the panels, right? So I'm just going to use the D's and the R's, all right? So the D's are like, the R's are awful, horrible. I mean, some of the D's, not all of the D's. And then the R's are like, whoa, Crimea River and blah, blah, blah. D's are whatever it is they think, they're putting it on government websites. So the question then becomes to the R's, do you just want to have your party then in power? And that's the question then that we have to ask the D's as well. So if these guys are awful, then you just want your party to be in charge. You only want one party. And usually the answer is going to be no. They don't want one party, but they also don't want what is existing right now. So that's why things get so tangled up, and it's hard to kind of get back to the middle again because we don't have an answer. We know we don't want, and even these people, these people here who are, and I say even though because they are a bit aggressive today, that's who I'm talking about today, they're not saying they only want one party. What they're saying is they don't want what they have. Ooh, USDA. They used to work together, right? I mean, they weren't friends, but there was mutual respect, right? And that's gone. And I think that's trying to, I guess, and I've said this before, trying to come back from something that has been so deeply hurtful, right, is very difficult. It's very difficult. So federal ranked choice voting. Oh my gosh, wouldn't that be amazing? That would be amazing. All right, back in it to win it, everybody. So despite the efforts of President Jefferson and others to keep partisan politics separate, I don't know that Jefferson did that actually, from the administration of the government, the political patronage expanded within the executive branch. Congress attempted to rein in the patronage system. With the Pendleton Civil Service Reform Act of 1883. Of course they did. That was a great act, 1883. Which created a merit-based civil service system. And the Federal Civil Service Commission. So that's why we even had all of that. And I know there's this like, oh, well, there's too much waste going on. So we need to clean up all the waste and all of the, inflated stuff. And it's like you took apart Thomas Jefferson's dream, people. Oh my gosh. Radical, well, of course, the radical piece, exactly. It'd be a lot easier. I agree. Thank you, Thomas. I agree, and I think a lot of people agree. A lot of people agree that the system isn't quite working. But you can't fix it if you can't get everybody to the table in a way that makes it so they're not throwing the turkey at people, you know what I'm saying? That's how I get, Danny, thank you. Right. Oh my gosh. Yeah, we're having some communication problems, everybody. All right, we broke up. We've already divided a lot of the assets, and now we're like, I'm not coming back to the table to talk about anything else. Meanwhile, we still have stuff that we got to split up. So it's a problem. All right, here we go. So the civil service rule, 1 had stated no person in the executive civil service shall use his official authority or influence for the purpose of interfering with an ally or affecting the result thereof. However, even after the Pendleton Act, roughly 2/3 of the federal employees remained outside of the civil service and were not subject to Rule 1. The Ellie of 1938 demonstrated the corrupting effect that a federal workforce largely exempt from limitations on using its powers and influence for partisan aims could have on elections. In one egregious case, an entire regional supervisory force of the Works Progress Administration, so WPA, was used to determine that political affiliation of 18,000 WPA employees. So let's just make sure we have that bit correct. The resulting list was handed to political campaigns and the employees not supportive of that federal relief program I'm sorry, hold on here. My mind's wandering here for a second. Give me a second, everybody. I apologize. I blame the cough syrup. Here we go. And employees not supportive of that campaign's candidate were fired. All right, so look at this. This has happened before. Look at that. They took information down, they put it into a list, and depending on which candidate you supported, you kept or lost your job. All right, another example involves 70 individuals hired under a federal relief program who did no highway work at all during the period they were on the rolls, but upon reporting for work, were instructed to go back to their respective precincts and canvass them in behalf of partisan political campaigns. So we've been down this road a little bit before. Michael James, exactly. In response, in 1939, Congress passed an act to prevent pernicious political activity. Who named this act? That's ridiculous. I'm sorry. I'm kidding. Ah, my gosh, I'm going to be turning into a pumpkin soon, everybody. Here we go. Let me wrap this up. In response, in 1939, Congress passed an act to prevent pernicious political activities, commonly referred to as the Hatch Act. Section 9 made it unlawful for any person employed in the executive branch of the federal government or any agency or department thereof to use his official authority or influence for the purpose of interfering with an election or affecting the result thereof. Congress intentionally made Section 9, now 5 USC, Section 7323, virtually identical to Civil Service Rule 1, but notably expanded the prohibitions to cover essentially all executive branch employees. In doing so, Congress aimed to further insulate government administration from partisan politics and prevent federal employees from creating a powerful, invincible, and perhaps corrupt political machine within the federal government. So we've been here before, everyone. One more paragraph here. The Hatch Act does not define official authority or influence, but congressional debates show it was interpreted broadly. Senators also distinguish between actions taken in an official capacity, which implicate the use of official authority, and those taken as a private citizen, which do not. Again, this is that immunity decision out of the Supreme Court, and the breadth of abuses to which Congress was responding, including creation of taxpayer-funded campaign staff, provides additional context. So look at this. Look at that. We've got the history here, right? So it's nice. I mean, it's awful. You shouldn't do this, but look at that. We've got, this isn't the first time. So I will go ahead and stop here for tonight because I'm getting a little goofy. So I can tell. Things are going to go downhill quick after this. So let me put a little sticky there. But all right, so far, what are your thoughts, everybody? What are we thinking? We started again talking about the wording, the phrasing, especially the derogatory wording that have been sent out with various emails from the government and government websites. And the question is, do those violate the Hatch Act? And, you know, what are our thoughts? What are we thinking? What are we thinking with that? Oh, Big Grandma, of course. Oh, I'm so glad to be back. Very glad to be back. Doesn't seem good. Okay. Yes. Okay. Right. Oh, right. Yes. Yes, they do. Okay. So our first question then, and again, this is what's haunting all of us, everyone. So we have a violation of the Hatch Act because we've got somebody putting this information on government websites, right? The Hatch Act, though, was it the president or the VP that told somebody to do that? That's the next question. Because if it was the president or the VP, the Hatch Act is not applicable. Because FDR was mad at the Dems. Well, yeah, I mean, right. There's a lot going on there. There's some complicated relationships with FDR, for sure. Right. Oh my gosh, they should move out, exactly. Oh my gosh. But the executive branch is responsible for the enforcement. Exactly right. That's one of the big problems. Right. So we don't know if the president or VP. So this is unknown here, right? So that was a trick question. So first of all, we don't know if the president ordered it or the VP. With the micromanaging that's been going on in this administration, I'm bound to say yes, he probably did order it, and whatever. Probably doesn't know what it is now, but whatever. The second part here we have is, so what, right? So what if they violated the Hatch Act? How are they going to be held accountable here? Are they going to have some kind of a negative sanction involved because of the administration? Those are the other questions here, right? The road crew begins to go campaign. I think you're right. It's just so juvenile. My goodness gracious, it really is. It really is. We, excuse me, for sure. We all kind of, not we all, but I got that vibe off of George W. Bush. It was a little bit like, oh, Excuse me. You seem a little young for your role here, sir. That's nothing. Trump's like, hold my beer. No, there's no fines that are specified in here. There's no specific punishment. Although, let me take a look. Let me take a look here. I'm going to say that, and then there's going to be a fine. I'm going to feel terrible. So let's take a look here. So paragraph A, here we go. Permitting applicability, state and local employees. Yikes. Let me go over here. Here's penalties right here, okay? So penalties, an employee or individual who violates section 7323 or 7324. 73 here. I'm not 100% sure because this is affecting just this piece of it, so I don't know if another piece would be involved here. But they're subject to removal, reduction in grade, debarment from the federal employment for a period not to exceed 5 years, suspension, reprimand, or an assessment, or, all right, so all of that can happen, or an assessment of a civil penalty not to exceed $1,000. So it does look like the 1K is included. So good catch, very good catch on that. Because I'm wondering now if you get the choice, you'll have the choice. We can do all of these things, or you can give us $1,000. It's up to Congress to decide what to do with it. To do with what? To do with, right? To do with what? That's why we're, that's why this whole thing is so bananas, everybody. Because who enforces the law? I know, right? Like, exactly. CompuBear. That's the whole thing. Exactly. So, and I've heard that like in my dreams. I've woken up to hearing like, oh, my bar says that. And I've like, wake up and my hubs is like, what? What'd you just say? I'm like, oh my gosh, okay. But here's the problem, right? So if we have, we're talking about executive people, executive office people, all right, violating a federal law. Who brings the suit? Who brings the lawsuit? The president is the only one that can excuse me, give any kind of sanctions regarding their jobs, right? But who would bring this in front of the court? That's the question. Excuse me. And the answer is nobody. Yeah, so the president doesn't have to worry about the Hatch Act. He's not covered under that. Pattern of behavior for other violations. True. But who brings it, right? I mean, it's not a criminal case, it's a civil case. So that means a lawsuit would need to be filed in order for them to be held accountable. So who is, excuse me, filing the lawsuits? Oh my gosh, everybody, I'm sorry. You can think about that. I'm gonna go ahead and go. I need more Robitussin. So, with that, my friends, I will sign off for tonight. Hopefully, you've learned something new here, something interesting. So, feel free to make any comments, and I will try to get to them as soon as possible. And I'll be back again. So, take care, everyone. Thanks for coming by.